One day, your credit score is fine. The next day, it's tanking because of an account you never applied for, or discovering that somebody pulled your credit when you never applied for anything. Most people think they're stuck with it, but the Fair Credit Reporting Act, also known as the FCRA, gives consumers important rights when it comes to their credit reports. Today, we're going to break down two of the most talked about sections of the FCRA, FCRA 605B and FCRA 604. By the end of this video, you'll understand what these laws actually do, how they protect consumers, and when they may apply to situations on your credit report. Let's start with FCRA 605B. FCRA 605B deals with identity theft and the rights of consumers who become victims of it. If information appears on your credit report because somebody used your identity without permission, the credit bureaus may be required to block that information after receiving proper documentation. A lot of people misunderstand this law. It doesn't automatically remove accounts just because you say they're fraudulent. The documentation is what matters. The credit bureaus typically need enough information to determine that the account resulted from identity theft. Think about it from their perspective. If anybody could simply write a letter saying, "That's not mine," every negative account would disappear overnight. That's why documentation is such a major part of the process. For example, imagine someone steals your identity and opens a credit card in your name. Months later, you discover a charged-off account with thousands of dollars in unpaid balances showing up on your credit report. You gather the necessary documentation, identify the account, and submit evidence showing the account was opened through identity theft. Under FCRA 605B, that information may qualify to be blocked from your credit report while the matter is investigated. Here's another example. Let's say you apply for an apartment and suddenly discover a utility account from another state. The problem is you've never lived there. You've never opened an account there. You've never even visited that area. After gathering documentation and showing that the account resulted from identity theft, FCRA 605B provides a process for consumers to challenge that reporting. The biggest mistake many people make is submitting incomplete information. The credit bureaus need to verify who they're communicating with. That's why consumers are often asked for identification and proof of address. The goal is to ensure the bureau is dealing with the correct consumer and evaluating the correct information. Now let's move on to FCRA 604. This section deals with something known as permissible purpose. In simple terms, companies cannot access your credit report whenever they feel like it. Generally speaking, they need a legally recognized reason to obtain your consumer report. Some examples include applying for a loan, applying for a credit card, applying for an apartment, certain employment situations where allowed by law, insurance underwriting, and account reviews by existing creditors. Here's a simple example. You walk into a bank and apply for a personal loan. The bank pulls your credit report. That is generally considered a permissible purpose because you initiated the application. Now let's look at another example. Imagine checking your credit report and seeing an inquiry from a company you've never heard of. You never submitted an application. You never requested credit. You don't recognize the company at all. In situations like that, consumers have the right to ask questions and dispute information they believe is inaccurate or unauthorized. The company should be able to identify the reason they accessed your report. This is why understanding FCRA 604 is so important. It helps consumers understand that there are rules regarding who can access their credit information and why. Another topic that often comes up during disputes is Metro 2 reporting. Metro 2 is the reporting standard many lenders and furnishers use when sending information to the credit bureaus. The goal is consistency and accuracy. Sometimes consumers discover reporting errors such as incorrect balances, inaccurate payment history, incorrect account status, duplicate accounts, wrong dates, or personal information that doesn't belong to them. When information is inaccurate, consumers have the right to dispute it and request an investigation. That's one of the core purposes of the Fair Credit Reporting Act, promoting fairness and accuracy in consumer reporting. The biggest takeaway from this video is simple. FCRA 605B focuses on identity theft and gives consumers rights when fraudulent accounts appear on their reports. FCRA 604 focuses on permissible purpose and helps determine when a company has a legal reason to access your credit report. Neither law is a magic loophole. They're consumer protection laws designed to help ensure information on your credit report is accurate, fair, and properly reported. The more you understand your rights, the better equipped you'll be to identify errors, ask the right questions, and protect your credit profile. I hope you found this video helpful. Subscribe and like the video that helps the channel grow more. Free methods in our Telegram channel link in description. See you in the next video.